All right. Hello, everyone, and welcome. My name is Mariah Kruger. I'm the Housing Program Manager and Resource Attorney at Volunteer Lawyers Network. I'm here today with Beth Kelly, another staff attorney at VLN in the Housing Program, to provide this CLE training on eviction defense during the pandemic. We'll jump right into it because we have a lot to cover in this hour, but two things before we do start. Because we are requesting CLE credit for this training, if you would type your name into the chat box, it's private, it won't go out to everyone on this CLE, and that will allow us to track who was present at our presentation. Other note is we will type the CLE code into the chat box also so that you will all be able to see that, and that will be in the public chat box. Next slide, please. For this training today, we want to provide a broad overview of what eviction defense during the pandemic looks like. And I'll be honest with you right up front, our purpose here today is to generate interest in the initial appearance clinics that we're running through the housing program at Volunteer Lawyers Network. We could use more lawyers and thought that doing a training on what's going on would be a great way to help recruit more people for our programs. A note though, this is not a comprehensive training of all eviction defenses. We certainly couldn't do that in an hour and not even two. But we did want to start by just giving that overview, showing people how to issue spot, and then point people in the right direction for more information if needed. Next slide, please. So what we will cover today is a quick overview of the eviction process. Then we'll move into the common eviction defenses that we are seeing during the moratorium. We're going to talk briefly about settlement provisions, and then I'll pass it over to my colleague Beth, who's going to talk a little bit more about our clinic services at the initial appearance calendars and additional resources that we have available for our volunteers. Next slide, please. Before I get too far into it, though, I do want to give a brief overview about Volunteer Lawyers Network, our organization. We've been around for over 50 years now, and our mission is to protect and promote the rights of low-income Minnesotans through the power of volunteers. We provide services in many different legal areas: immigration, bankruptcy, family, civil, criminal expungement, and housing. In our housing program, we primarily provide services in three different ways. The first one is through our eviction expungement clinics and our eviction expungement full rep program. It's a great place for brand new volunteers to start. It's actually looking at eviction cases after the fact to see if there are defenses that could have been raised, and also helping a client state why an eviction on their record is no longer an adequate reflection of their ability to be a good tenant and get it removed from their record. All of our training and forms needed are online, and we really encourage new volunteers, if they're interested in getting started, to start with eviction expungement. One other good place for new volunteers to get started is with our phone advice clinics. Now, pre-pandemic, most of our services were provided at our courthouse clinics. Because we're not able to provide those services in person right now, we are doing phone advice. We do them every day of the week from 2 to 4 p.m. We also have our training online, and it's another good spot for new volunteers to get started. Today, we're going to talk more about our initial appearance clinics. And I'll be honest with you, right at the forefront, it's more of an intermediate to an advanced volunteer experience, but it's still important, we think, for lots of people to know about it and start to think about it to be something that they might be interested in. Also, we are looking at the eventual end of the eviction moratorium that's going on, and at that time there will be a great need for many people to help tenants who are going through eviction, and we're hoping there'll be a large number of you, our volunteers, who will be willing to volunteer during that time too. Starting at the initial appearance clinics now is a good way to get prepared for that. There are some different issues that are seen now, but there are some issues that are the same. So if you are one of those people who really do want to be involved at the end of the moratorium, I would encourage you to think about starting even right now. Something else I want our volunteers to know is, we do serve people based on income, and they're required to have a low income. We also do serve landlords. Landlords must also qualify income-wise, and they must be seeking services with an owner-occupied unit. We see this most frequently with the accidental landlords, people who maybe need to evict a tenant or have a family member or some familial relationship that is calling for an eviction. So we also do advise from the tenant or the landlord side also. Next slide, please. This slide provides an overview of the eviction process from beginning to essentially the end. The very thing that we have on the process is this notice of intent to evict, with a little note that this is new. A notice for an intent to evict is not something that normally happens in Minnesota. Tenants can be evicted without notice, except here in the moratorium. We're going to talk more about Executive Order 2079, which has put the Minnesota eviction moratorium in place. And that order requires landlords to provide tenants a notice of why they are going to be evicted before the eviction action is even filed. I think it's a great new addition to our eviction law in that tenants should receive some type of notice before an eviction is filed against him. And we'll see if it's something that sticks around after the moratorium ends. But it is something that's new and right now only during this pandemic period. Every case is started with a filing of an eviction action and then service of that eviction action. And I have these separated on the eviction process because I'd like you to know that the filing of an eviction action is what puts a eviction on a tenant's record. The moment that action is filed is the moment that tenant then has this eviction on their record, which is going to change their ability to get future housing. It's only after that it's been filed later on that it's served, and the complaint must be served 7 days before the initial appearance hearing. The initial appearance is the first time that the parties appear in court to discuss their case. That initial appearance hearing is going to be scheduled by the court between 7 to 14 days from when the action is filed. So it happens relatively quickly. At that initial appearance, we're going to talk a little bit more about it, but that's where our clinics come in. That's where we want to have attorneys advising tenants and some landlords on what defenses, what their case is like, if it's proceeding forward, and help them answer any questions that the client might have. At the initial appearance, several different things can happen. The case can get settled between the parties, which is what we see probably most frequently. The case can end at that point either by a default from either party, or can be dismissed by the court, or it can be set for trial. If it is set for trial, what comes next is a discovery deadline and a trial. Now, normally, by statute, courts are required to set trials within 6 days of the initial appearance. There is some leeway with that during this peacetime emergency. Courts have the statutory deadlines have been relaxed during the peacetime emergency. And I can say even outside of the peacetime emergency, sometimes courts aren't able to schedule them within that 6 days. But the scheduling of the trials generally does come quite quickly after the initial appearance hearing, or parties can agree to schedule it later also. After the trial, if it goes to a decision, there's always an opportunity for a judge review or an appeal. Really, there's the opportunity for a judge review or appeal at any time there's a final order in a case. A judge review in Hennepin and Ramsey County, initial appearance and trials are heard by referees. So if you want, you can have a judge review the decision by the referee. Elsewhere in Minnesota, you can go straight to an appeal. And you can also go straight to an appeal in Hennepin and Ramsey County too. So at the very end of the case, or at the end of any final order, if it is that the tenant needs to move, there will be a writ that's issued by the court. And then ultimately, if the sheriff is forced to remove the tenant, the execution of the writ. And I put these both on here just because I wanted to make the distinction between an issuance of a writ and the execution of a writ. There are many, many writs that are issued that ultimately aren't executed on, meaning that the sheriff doesn't ultimately come and remove the tenant. When a writ is issued, what happens is the sheriff can post the writ on the tenant's door, and that writ will say the tenant has 24 hours to leave before the sheriff comes back. Now, the sheriff rarely comes back exactly 24 hours later, and it really depends on how busy the sheriff is at that time. But sometime after that 24-hour period, the sheriff will come back and remove the tenant. There's also statutory requirement that landlords tell tenants when the actual date and time for the removal is scheduled. I'm always a little leery that landlords actually follow that, but so tenants should have some notice of when the actual removal will take place. A couple other notes about eviction actions. Eviction actions are summary actions and they move quite quickly. And I hope I made that clear in my chart above. Minnesota has a very fast eviction process. 7 to 14 days is the initial appearance after that action has been filed, 6 days trial after that, and sometimes tenants can ask for up to 7 days to move if they've received a final order and need time to move. But all of that, if you're moving your residence, is not much time to move. Evictions are actions to cover possession. And I would say housing court in general is a place that deals with the possession of the premises. So if tenants or if parties are just arguing about money, about property, and the tenant is no longer living in that unit, then that case needs to go to conciliation court. Eviction actions and housing court in general is really concerned with tenants and landlords who are in the current situation and the tenant is occupying the premises. Really important to know is that landlords cannot forcibly remove tenants outside of an eviction action. A landlord must, if they want to remove a tenant, go through the eviction action, and to not do that is a minimum of a $500 fine or treble the damages, whatever is higher, and can be a misdemeanor. So it really is important that landlords use the eviction process if they want if a tenant should no longer be in a unit. Eviction law is governed by Minnesota Statute 504B, and in Hennepin and Ramsey counties, they have the Minnesota Rules of Practice 601 to 612, which apply there. Next slide, please. Just a little bit more information about the first appearance calendar, because that's really where we're recruiting people for here today, is to help out parties coming through that initial appearance. And this once again is where the parties meet for the first time. We staff initial appearance clinics in Hennepin, Ramsey, and Anoka counties. Right now it's all via Zoom. Nobody has to leave their home, frankly, to get to court. And we partner with several organizations in the provision of the services. We're very proud partners with legal aid organizations, MMLA in Hennepin County, SMERLS in Ramsey County, and CMLS in Anoka County. There are also mediators available at all of the initial appearance calendars. So tenants and landlords who want help negotiating an agreement and don't have landlord or don't have attorneys who are helping them along with that can also use mediation services, excuse me. And finally, there are financial assistance organizations available. They're not as available right now because as we get into non-payment of rent is not a reason for eviction right now, but certainly during non-pandemic times, normal times, our financial assistance partners are extremely important partners at the initial appearance cases. Once again, real quick, the potential outcomes of the first appearance calendars. What the court is not going to do is it's not going to take in any evidence. There are no evidentiary hearings. This is really the opportunity for the parties to get together and figure out what's going on. Once again, one party can win through default. Sometimes landlords don't show up. Sometimes tenants don't show up. Sometimes the cases can be dismissed outright, and we'll talk about some situations why the court will do that next. The case can be continued for an additional initial appearance if the parties need more time. A case can also be settled, and I would say the vast majority of cases are settled at the initial appearance calendars. The court does encourage the parties to settle. Their belief is that it gives parties the most certainty and say in over their situation, what happens, as opposed to rolling the dice and going to trial and getting a decision from the court. So a large number settle, but we are seeing more cases now go to trial during the eviction moratorium. And I think part of that is people also have less options to move, and the cases are messier, more fact-based. So cases can also be set for trial at the initial appearance hearing. Next slide, please. All right, next we're going to move into the common eviction defenses during the pandemic. And this is what we're asking our volunteers to do at the initial appearance clinics. We're asking them to sit down, take a look at the paperwork, talk with their clients, and go through these defenses and see what settlement leverage they have. Should they go to trial? What does their case look like? And help them decide what the next best steps for them would be. Next slide, please. We're going to start with Minnesota's eviction moratorium through Executive Order 2079. So 2079 came into force August 4th, 2020, but we've actually had eviction moratoriums here in Minnesota since March 24th, 2020. We first had Executive Order 2014 and it was amended by 2073. And then those were both rescinded, and the current order, which has remained in place now since early August, is what is in effect. It will remain in effect until the peacetime emergency is terminated, and the peacetime emergency must be renewed every 30 days. And at that 30-day mark, the legislature has an opportunity to override the governor's peacetime emergency powers. To override, it must be a simple majority vote in both houses. And right now we have a Democratic governor, a Democratic House, and a Republican majority Senate. So it's possible that both bodies could vote to override, but it seems unlikely. The other way that the Minnesota's moratorium could end could be rescinded by proper authority. And this would be if the legislature decided to pass something which would change the moratorium. And this, I think, is probably the more likely way that the moratorium would end. There have been some discussions now during this legislative session about what an off-ramp to the moratorium would look like. One of the benefits of creating an off-ramp is right now the moratorium just ends, if it were to end. There's no notice to people that it would end. There's no determining which cases are the most important to go forward first. There really is just this cliff that we'd all fall off together. If we put on some sort of off-ramp which helps prioritize cases a bit, maybe put a 30 to 60 day warning on it so people get an advance notice, make sure it's tied to funding and funding be available, would help everybody plan to some extent. But it's in the hands of our legislatures right now, so we'll see what happens, if anything. Next slide, please. So Minnesota's moratorium right now essentially prohibits moratorium for anything except for, and it's essentially 4 specific areas. This order itself says those areas are the seriously endangering the safety of others, violations of Minnesota Statute 504B 171 Subdivision 1, and these are for certain criminal activities. We'll talk about those a little bit more in a few minutes. It's controlled substances, prostitution, robbery, and guns are the main areas that are affected by that. Remaining in the property after receiving a notice to vacate or non-renewal where the property owner or property owner's family member needs to move in within 7 days of the tenant leaving. We'll talk about the details of that one a little bit more in another slide. And also, if there's a material violation of the lease by either seriously endangering the safety of others or significantly damaging the property. These actions must occur on the premise, including the common areas or the curtilage. One thing that the Minnesota's moratorium does not do is it does not permit eviction for non-payment of rent. But on the same hand, rent is still due. Tenants need to be paying rent. There is no rent holiday in Minnesota right now. And the hope is that for those that are without jobs, have been unable to work because of the pandemic, will be able to access funding. And we had our first round of funding this fall. Another round of funding should be coming out in the coming weeks. Next slide, please. Before I get into the details more of the Minnesota moratorium, I just wanted to touch on the CDC eviction moratorium. The Center for Disease Control does have a nationwide moratorium on eviction for non-payment of rent. And this is specifically where a tenant has provided a landlord with a signed declaration stating those things that I've listed on this slide here. And essentially what they need to say is that they're doing their best efforts to pay as much rent as they can, but they are unable to pay rent at this time. This came into effect on September 4th, 2020, and it's been renewed now at least until March 31st, 2021. I have heard rumblings that there's a desire to renew this with the Biden administration now into sometime possibly early fall. It's still all speculation at this point. But what I do want to point out a couple things here. The CDC moratorium right now, in general, does not apply in Minnesota. And that's because the CD moratorium states that it does not apply in states with moratoriums that provide the same or greater protection. Minnesota's moratorium provides greater protection for Minnesota renters right now. There is an argument that the CDC moratorium may provide certain protections in some specific areas in Minnesota, but in general, it does not apply in Minnesota. It's possible that it could. And one of the ideas of a potential off-ramp of Minnesota's eviction moratorium would be moving towards something more like the CDC moratorium or relying on the CDC moratorium instead of the Minnesota moratorium. Once again, this is all speculation on my part. We'll see what our legislative bodies decide, but wanted to make sure that you are aware that the CDC moratorium is out there, but just not currently applicable in general in Minnesota. Next slide, please. My first slide where I was talking about the eviction process, I noted that there is now a notice of intent to evict, which is necessary in Minnesota. That's based under the EO 2079, Minnesota's eviction moratorium. And that provides that property owners must give at least a 7-day notice of intent to evict unless the lease specifies a notice period that is longer. So there are some leases that will have a notice period, usually like 30 days. And if that's what the lease says, then the landlord also needs to follow that lease and provide a 30-day notice. And that notice is particularly nice because it gives the tenant an opportunity to remedy or to leave if that's what they want to do. And it also puts the tenant on notice as to why they are being evicted. So when we look at cases that are filed or at our initial appearance clinics, one of the things we want to see is we want to see that 7-day notice. Was the 7-day notice given? Did the landlord really wait 7 days then until filing that eviction action? And did the notice actually put the tenant on notice as to the specifics as to why they were being evicted? What was the exception under the moratorium and for what they were using for this eviction? So these are some of the things that we do look for at the initial appearance clinic to make sure that the landlords are complying with those requirements. One other note I want to include here is that there was the Federal CARES Act moratorium, and that took place for about 90 days from the end of March to the end of July. Now, in large part, that moratorium has expired and is no longer applicable, except there was one section in there that did not sunset the rest of the statute. And that was a 30-day notice was required for evictions for any, and it's not just non-payment, for any eviction for someone who lives in a covered property. Now, federal government can't legislate just anything they want. They have to have some type of nexus for it. So the idea of this covered property is a property that there's some type of federal nexus for. So this is any type of property that is subsidized housing property, most subsidized housing properties, and then also if there's a federally subsidized mortgage backing that property. If it is a covered property, and there's belief that it could be somewhere around possibly 50% of rental properties are a covered property, then that landlord also needs to have provided a 30-day notice to evict. VLN has done a practice tip if you want more information about it, and you also can read more about it in the information provided on this slide. Next slide, please. All right, moving under to the exceptions underneath EO 2079. I want to talk about violating essentially 504B171, so criminal violations. And that the Minnesota statute 504B171 subdivision 1 permits eviction when a tenant allows the following activities on the premises, common areas, or curtilages. And those are controlled substances, prostitution or prostitution-related activities, the unlawful use or possession of a firearm, and allowing stolen property or property attained through robbery. A couple things that when we see these, the couple things that we want to check for on them. If the landlord is going to object a violation of 171, they need to be able to improve all of the elements of the violation by the preponderance of the evidence. So one that we see reasonably frequently is controlled substances. And we do know from the court that simply smelling marijuana is not enough proof in order to evict a tenant. There needs to be something more than just smelling or seeing strange people come in and out of a home frequently. The landlord also needs to prove that the tenant must have known or had reason to know that the activity was unlawful. And another one, defense that could be raised here is that the tenant could not prevent the illegal drugs from being brought into the property. Next slide, please. So I want to move on to the breach of lease allegations, or the exceptions, excuse me. So these are for endangering others and damage to property. So these need to be brought as breach of lease claims. And there are a couple things that happens when it's brought as a breach of lease. Well, and first of all, they must occur on the rental property. So you can't see it happen down the block someplace, see it happen at the library 2 miles away. It needs to happen on the premises. The lease must be attached to the complaint. Now, if a lease is not attached to the complaint, a court is not likely to throw out a case because of that. But what you as an attorney could do would be to reach out to the other side and say, this is a breach of lease case. You need to attach a copy of the lease. And then in that lease, one of the things that we want to look for is that there needs to be a right of re-entry clause. What the right of re-entry clause does is it gives the landlord the right to evict for a breach of lease. Without having that right of re-entry clause in the lease, the landlord doesn't have the right to evict for that breach of lease, and it's a defense that should be raised on behalf of that tenant. Another thing you can look at with these breach of lease claims, the landlord must reasonably accommodate a tenant's disability. So certainly, looking at what the damage to the property is, what the damage to, or excuse me, what the endangerment to other people were, and is that based on some disability of the tenant? We had an interesting one come through where the woman was hard of hearing, and she talked really loudly all the time on the phone. And what it did is it led to a breakdown in relationships between this woman and her neighbor, and thus the endangering others ultimately came out of it. Well, really the crux of the problem was the woman's disability and her ability to hear. And when her hearing was fixed, the noise level went down, the tension went down. Another thing, mental health issues certainly are rampant during the COVID and the pandemic pressures? And are the tenants' behaviors which cause those problems based on a disability? If so, that's something that you should raise a reasonable accommodation issue. VLN is going to be having another training, and well, hopefully we're in the process of planning a training on reasonable accommodations in early March. So if that's something that you are interested in learning about, I would encourage you to attend that training. Some other notes about the seriously endangering. We've had some cases come through. Yelling isn't enough. Latent threats, courts have found, have not been enough. That there needs to be a serious endangerment to others, and we want people to look into the facts of what's going on in those situations. Was there a fear of endangerment that's actually been happening to others? Same with the damage to property. Was it significant? We've seen cases come through where there was damage, but the damage was repaired. The court didn't find it to be significant. Damage was of a small dollar value. Once again, the court didn't find it to be significant. So these are things that we just want to look at those complaints and make sure that the landlords are adequately alleging what needs to be alleged and bringing the evictions based on reasons permitted in the moratorium. What we do see sometimes is landlords who have not been paid, relationships are bad, and they frankly just want that tenant out. So what they'll do is they'll look at the 4 exceptions and try to squeeze some situation into one of those exceptions. The exceptions are narrowly written because we do know that keeping people housed keeps everybody safe in the pandemic. So we all have an interest right now in keeping as many people housed securely as possible. Still, there is that pressure from landlords and even landlords who particularly aren't being represented by counsel to try to fit a situation that really shouldn't be going through the eviction moratorium into one of the eviction moratorium exceptions. Next slide. Great. So the final one, and this is sort of just seems a little bit different of a category than endangering others and property damage and criminal violations, but the property owner or family member needs to move in. And here I put the language of the order right in for you because I think it's interesting. But so here's where the property owner issues a termination of lease or non-renewal of lease due to the need to move the property owner or property owner's family member into the property, where the property owner or property owner's family member will move in within 7 days after it's been vacated by the tenant. So there's been a lot of litigation going on about whether or not the property owner really needs to move in, whether there's been proper termination of the lease, all these things. So a couple things I would want my volunteers to consider if they see these cases coming through. First of all, has the tenancy or the lease been properly terminated? If it's a month-to-month lease, they need to give a month notice in 1 day. If the lease provides a different renewal or termination period, those need to be followed. Is the property owner need been demonstrated? Does the property owner have other business? I'm going to jump down one there. One thing that we've seen is if a property owner has several buildings, what is the need to move into that specific building? If it's another family member, where was that family member before? Where were they living? And why do they now currently need to move into this place? And there should be specific facts demonstrating why that need is. And it really is a factual inquiry, but it is an inquiry that landlords need to be able to answer to, and there needs to be a genuine need to move in. We've also had some litigation on property owners being a business, and some courts have held that business if you have someone evicted underneath this exception. Excuse me, I think I was off there for just a minute. So a business doesn't have a family member and really shouldn't be able to evict underneath this exception. One practice tip that we have learned at VLN is that if there is an eviction for a family member wanting to move in, if you do a settlement agreement, it helps to have in that settlement agreement that that family member is going to move in within 7 days. One of the problems with this is if the landlord doesn't move in with 7 days, how one enforces that after the fact. So one tip that we found is by putting that into the settlement agreement leads to a breach of the settlement agreement then if they haven't actually moved in within 7 days. Next slide, please. So moving on to some non-pandemic related defenses, I want to talk about service. Service in Minnesota needs to be strictly complied with. Therefore, every case should be analyzed for service defects. And if there are defects in service, there's a jurisdictional issue, and the party should request dismissal and expungement of that case. A note here, it's not an actual service requirement. So frequently have tenants come in and they're like, well, I never knew about this. Well, it's not actual notice, but there are some very specific rules in how that notice needs to be provided that must be followed. Also, service must be completed at least 7 days before the initial appearance, can't be on legal holidays, and it needs to be completed by a non-party. So certainly can't be the named plaintiff, can't be the named plaintiff's spouse or domestic partner, shouldn't be an agent, management agent of the property owner either. It should be a disinterested party. Next slide, please. There are 3 types of service: personal service, substitute service, and alternative service. Personal service, once again, just needs to be completed within 7 days and needs to be a non-party handing the complaint to the tenant. Substitute service means that if the plaintiff cannot find, or if the landlord cannot find the defendant, that they can then substitute service on another person. That person, however, needs to reside at the defendant's usual place of abode and needs to be of reasonable age and discretion. So this means that if grandma is visiting from Arizona for 3 weeks to help take care of the kids in the spring, serving grandma doesn't reside there. Reasonable age, 10, 12, 13, 10's in the bottom of that range, 12, 13 is in there. But also discretion if it's grandma has Alzheimer's, 15-year-old daughter is developmentally delayed, once again, not proper age and discretion. Alternative service by mail and post is where we see the most mistakes because it is the most complicated. If the landlord is unable to personally serve or do substitute service, then the landlord needs to do alternative service. Alternative service happens when 2 attempts have been made to personally serve the defendant. One needs between the hours of 6 and 10 p.m. Then they need to file an affidavit saying that the defendant cannot be found with the court. The landlord must mail a summons and complaint and file an affidavit of service by mail. And finally, after all these things are done, then the tenant may post the summons and complaint on the door and file an affidavit of posting. What this essentially means is that the landlord needs to go out to the property 3 times in order to properly do this service. They need to go out and serve on at least 2 different days, attempt personal service, then do the mailing, and then on that 3rd time to go back and do the affidavit of posting. Before the posting is made, the landlord should have filed the affidavit of not found by the defendant, should have filed with the court their other attempts to serve the plaintiff, to serve the tenant, and then the posting must be made. So there's a lot that's been written on this. There's something that really we do want to make sure service is done correctly. Strict compliance is required. There's a little bit of varying enforcement of this in the jurisdictions, but we certainly do see cases being dismissed quite frequently for bad service. Next slide, please. Couple other things, preconditions to recovery, some more pleading requirements, essentially things that need to be covered before the case really can be moved forward. One is the action must be commenced by the person entitled to the premises or the authorized agent of the owner. So we call this the proper plaintiff defense. What this means is the person who is bringing the complaint, who's named in the complaint, must be the property owner. This is something we can check pretty readily, particularly in Hennepin and Ramsey County. We can look up the property records and see who owns the building. Now, let's say you get a case and you look up the property owner and it's not the person named as the plaintiff. Next thing that needs to happen is you need to reach out to that landlord or the landlord's attorney and find out who that plaintiff is and how they are a properly authorized agent. Maybe the lease is signed between the tenant and this plaintiff. That might be a way. But they should be able to come up with some sort of documentation that shows that this is the proper party to bring the case. If not, the case should be dismissed for lack of a proper plaintiff. Also, another thing that's important, and just on the notice front for tenants, and in fairness to tenants, that the name of the person authorized to manage the property and a physical address for service must have been posted on the property, or there must be proof that it was disclosed to the tenant at least 30 days prior to the eviction filing. And this is supposed to be disclosed in the eviction action complaint itself. And once again, this is a protection of the tenant's rights. And really here, if the tenant wanted to complain to the landlord, most likely about repairs would be one issue, or any other issue, did they have a way to contact that landlord, to serve that landlord if necessary? And that should be pled in the complaint. The complaint must state facts supporting the basis for recovery of the premises. So this is once again putting the tenant on notice as to why they're being evicted. There should be enough facts, particularly when it comes to breach of lease claims or moving a family member in, that the tenant knows why they are being evicted. I think just to note is that artificial entities such as corporations and LLCs must be represented by attorneys except in Hennepin and Ramsey County. There's a rule of general practice 603, only applicable in Ramsey and Hennepin County, that does say that landlords may use a non-licensed agent to proceed with their case, but if they're going to do that, they need to have a power of authority attached to their complaint. So if it's not an attorney, you'll need to look for that power of authority. And once again, if that power authority is not attached, you need to reach out to that landlord counsel and find out why it's not, and potentially ask for dismissal of the case for, once again, improper proceeding. Next slide, please. Some other defenses just want to touch on. Landlord must be properly licensed by the city. This is particularly important for City of Minneapolis cases. City of Minneapolis has a great website that you can type in an address and you can find out whether or not there is a current rental license on that property. Additionally, City of Minneapolis has an ordinance that says if a landlord is not properly licensed, they may not collect rent. So landlord without a license is a strong reason that an eviction case should be dismissed and expunged. You can check licenses in other cities also. It's a call. The City of St. Paul has a website, which I also recommend to call if you don't find the information that you're looking for, to the Department of Safety and Inspection, and also in any other cities. Licensing is a city issue, so you do need to check with the city, and the ordinance vary a bit by city by city, but we certainly want to make sure that in the City of Minneapolis, we're checking all of these cases. Another one that comes up a little bit more frequently, or at least we see in these pandemic cases, is the tenant is the victim of domestic abuse. So if the landlord is alleging property damage, particularly, or endangering others, is it the abuser that's causing the property damage? Is it the abuser that's threatening others? If so, the victim here has rights as a domestic abuse victim, and those should be raised at the initial appearance. Is the landlord retaliating against the tenants for complaining to enforce their rights under the lease, state or local law, or residential covenants? So this is the eviction retaliatory? Has the tenant asked for repairs and for the landlord to make those repairs, and the landlord maybe hasn't done them yet, or maybe has done them and wants to evict them afterwards? This is another defense that we want to look at and help tenants raise at the initial appearance calendar. Is the tenant behavior based on disability? We talked a little bit about this previously. You can request a reasonable accommodation under the Fair Housing Act, and we're looking forward to providing you further training on how to do this. Also, it was the tenant who called the police or emergency assistance, and we're seeing this quite frequently with the 504B171 evictions. There was the tenant who was calling for protection, and frequently landlords, what they'll do is they'll attach police reports to prove that these allegations are true or the criminal activities, and the police come out and write reports, but it's the tenant themselves that has been calling the police. And it certainly is the right for the tenant to call the police without any detriment to their rental unit or risking eviction. Next slide, please. All right, I believe I've gave you a pretty good list of things that we want people to look for when we're looking over cases at the initial appearance calendars. We are putting together a checklist that we're going to make available on our website. It's a shortened checklist. There is a much more in-depth checklist if you ever check out Larry McDonough's Eviction Action Complaint, which is a fabulous resource to use. Our checklist will be a little bit of a shortened checklist just to recognize the time pressures that can happen at the initial appearance clinics, but we encourage volunteers to take use of both of those. One other thing we just wanted to talk briefly about today is settlement, because settlement is a big part of what happens at the initial appearance calendars. And one of the things I always try to do when I'm advising at initial appearance calendars is ask the tenant what it is that they want. Do they want to stay? Do they want to leave? If they want to leave, what do they need to leave? If they want to stay, what do they need to stay? And all of these things can be put into some type of settlement agreement. Some common provisions we have in settlement agreements, one thing is a move-out date. And if you are negotiating for a move-out date, I would say be as specific about that move-out date as you can. If it's going to be March 3rd, is it March 3rd at 5 p.m. and the tenant is going to go to the management office and turn in the keys, or the tenant is going to put the keys into an envelope and put them into the deposit box, or the tenant at 5 p.m. is going to call the landlord on their phone to turn in those keys. It's important to put in those specifics so that that move-out date goes smoothly. Also, is there rental forgiveness? And I think this is particularly important. Right now, the rental assistance that is available to people is only available if they continue to rent in a property. So if someone is going to leave a property, that won't then be able to get rental assistance to pay back that landlord. So sometimes it behooves tenants to stay in that rental property just so that they can access rental assistance and pay all that backed rent to the landlord. If the landlord really wants them out, maybe the landlord then, and I would suggest the landlord then should forgive the tenant of that backed rent and write that into the settlement agreement so that the tenant doesn't leave the property then and have this large rental balance due and owing against them going forward. It's also really important to talk about expungement. Like I said, once an eviction is filed, it's on that tenant's record from that moment forward until it is expunged by a court, and it doesn't happen automatically. So expungement, it can happen at the end of a settlement agreement once the parties have adequately satisfied all of the components of that settlement agreement. We also have something called an index and caption change. So while the settlement agreement is ongoing, the court can change the tenant's name to John or Jane Doe and therefore give the tenant some protections while looking for new rental properties and having not yet completed that settlement agreement. Neutral reference is also another important one, and if you can get the landlord to agree to not provide a negative reference or at least a neutral reference, that's very helpful as tenants are seeking housing elsewhere. Repairs to be completed by the landlord doesn't have to be all tenant obligations in the settlement agreements. It can be an obligation on the landlord to make some repairs that the tenant has been asking for quite some time. Also, sometimes last chance agreements, one more opportunity for a tenant to change their behavior, and if they can keep that behavior changed, they can stay. A payment to move called cash for keys. Sometimes a landlord will be willing to pay a tenant X amount of dollars just in order to have them leave by a certain date. And it certainly isn't for a tenant then to get out on that date and time. Once again, which landlord says owner move in. If the eviction is based on a landlord needing to move a family member within 7 days, I would put something in the settlement agreement about that, just in case it doesn't happen, that you have a little continuing leverage with the court to make sure that it actually does happen. And then other things, security deposits, be creative. This is the opportunity for the parties to fix their issues. And, you know, it might be something that we've never done before, but if it's what the parties need to fix their issues, that's what the settlement agreement is all about. So with that, I have covered pretty much everything that I wanted to cover for sort of the services that we are hoping to provide at the initial appearance calendar. What I'd like to do now is turn it over to Beth Kelly, another staff attorney in VLN's housing program, and she is going to talk more about the procedural specifics of clinic services. So take it away, Beth.
Apologize to unmute myself. Hi, my name is Beth Kelly. I am a housing resource attorney with Volunteer Lawyer Network. I'm going to talk to you about how initial appearance clinics work at the housing court. Next slide, please. So we have initial appearance calendars in 3 different counties: Anoka County on Wednesdays in the morning, Hennepin County currently on Tuesday and Thursdays in the morning, and Ramsey County on Tuesday or Thursday mornings. Everyone is appearing by Zoom. The court staff, all the parties appear by Zoom or phone, and the attorneys appear that way too. We have other service providers who join at the calendars as well. Our legal aid partners in the different counties, mediation services and financial services are generally there too. And there's also going to always be a VLN staff member at the calendar. So there will always be someone there for you to talk to as a volunteer about something that you need to know about that VLN can help with. Next slide, please. So before the calendar, VLN will provide you with the Zoom link. Of course, every county is doing things kind of differently. Ramsey and Hennepin, there will be one Zoom link, and that Zoom link will be where there will be volunteer services provided to tenants and landlords, and where court will also occur. For Anoka County, there are 2 links. The legal services has their own link, and there is a separate link for court appearances. We at VLN will also provide a volunteer who's going to staff a calendar, a copy of the court calendar with all of the cases before the day of court. Once you are at the housing clinic volunteering, once a client has gone through our intake, if we're going to be able to provide them with help, a VLN staff member will provide the volunteer, generally over email, with copies of all the documents that have been filed with the court on a particular case. That will, of course, always include the complaint and service documents, but there might be other documents as well. Also, a VLN staff attorney will always be available for consultation during the court clinics for any questions a volunteer has. Next slide. So there are basically 3 types of services that we ask VLN volunteers to consider. The court clinics are always definitely advice clinics that after a client goes through intake, if they are eligible for VLN services, the volunteer will provide advice at least to the client. If you're doing advice only, you can refer a case to mediation to help with negotiation of a settlement if that is the way things are going. A VLN volunteer may also consider doing a limited representation that goes beyond advice only, helping to negotiate a settlement, making brief court appearances to perhaps raise legal arguments that might get the case dismissed at the first appearance. If the client is eligible, there's also the opportunity to do full representation of the client. That would mean that you would take the case on at the first appearance and follow it through until completion of the case. Or if the volunteer is not available or is not able to do full representation, but the client is eligible and you believe that client needs full representation, we would ask that you refer that back to VLN so that we can find another attorney to hopefully take that client on full representation for the eviction case. Next slide, please. So providing services at the court calendars, everything is done over Zoom. There are availability of multiple breakout rooms. For each of the calendars, you will have a waiting room / check-in room with the court staff. There is a there would be a breakout room for court, and in Anoka it would be a separate Zoom link. Volunteer attorney and their clients can use breakout rooms to consult about cases. And there would also be breakout rooms available to negotiate settlements or discuss things with the other side. Excuse me. So the advice is the volunteers, what we're asking them to do is review the case that they're assigned with the client, advise the tenant, answer questions. Another really important resource, excuse me, we have is we do have digital signature services available to help sign representation agreements or with a client or work on a settlement agreement. Next slide, please. Excuse me. Okay, so here are a couple helpful resources. VLN's website for housing has extensive information that is going to be helpful to any housing volunteer. Things on there include an eviction checklist, instructions for volunteering at a remote housing clinic that provides a lot more specific information than what I've just gone over. There are trainings, many different trainings available on the VLN website. Evictions Basics is a great place to start. We will be adding this training that you are watching right now. If you want to watch it again, it will be on the website shortly. And Larry McDonough's poverty law website that is talks about housing law is a must-have as a attorney who is going to handle housing issues. It goes in depth on the law. As Mariah pointed out, the eviction answer that Larry has on his website is a really great resource. It can be used for doing an answer, but also just using it as an in-depth checklist with a lot more citations as you're considering a case. And he also has trainings. And as I said, the eviction defense manual is such a benefit to any attorney working in this area. Next slide. So I want to, on my behalf and Mariah's and all of VLN, thank you for watching this CLE. We can assist clients without your help. And we really appreciate that you have come to this CLE, and please consider volunteering. As Mariah said, we really need people to volunteer for our clinics and help out tenants. There's a lot of need right now. And next slide. Please let us know if you have any questions. I believe we're asking people to put questions in the question or chat box. Thank you.
And I apologize, there's a technical issue with our Q&A today, so you can email me bridget.freed@vlnmn.org for your questions. That's BRIGID.FREED. And I do have a few questions already. Someone asked, if a tenant is receiving federal subsidies, such as HUD subsidies, does the CDC moratorium apply, or is the Minnesota moratorium still the only applicable moratorium?
So great question. The Minnesota moratorium does take precedence right now over the the CDC moratorium. And again, no evictions can occur for failure to pay rent, even though everyone should be paying their rent. So, and the CDC moratorium is about rent.
We have another question. Are you aware of any case law defining the provisions of Executive Order 20-79? Specifically, are there any cases defining what serious endangerment or significant property damage is?
There are district court cases that have made decisions on these issues, but there are no or very little, there is very little appeals court decision. There are very few appeals court decisions. I believe I'm aware of one that is out there. It's unpublished, and it is more about the immediacy of the problem as to whether the moratorium exception would apply. So endangering the safety of someone 6 to 9 months ago would not be something that would most likely work under the moratorium. We can certainly provide information about that case to whoever is interested. Let's see, are there any other questions, Bridget?
I've not received any more questions as of yet, but we can hang on a little longer if anyone wants to email.
Sure, we will hang on for one more minute to see if anyone else has questions, and you can also continue to email us after the presentation.
And if I could jump in, Bridget, why don't you put my and Beth's email into the chat box? And if anybody wants to talk to us more about volunteering, we would love to hear from you. Send us an email and we'll reach out to you about what next steps for volunteering for our initial clinics, parents clinics would be. And thank you, everyone. If you want to send us emails, we won't make you hang on here. Of course, you can shut us off anytime you want, right? But if we get emails or any email questions, we will make sure to respond to those. And if at any time you have any questions of us, we're happy to respond to those. Our job here is twofold. One of them is we're here to provide services for low-income Minnesotans. But our second job is to support you, our volunteers, in the work that you want to do and that we can help you find. So please don't ever hesitate to reach out to us with questions, ways that we can support you. It really is our job. Don't ever feel guilty. And thank you, everyone, for attending today, and we hope to hear from you in the future.